know how you and Katisha think you can change my exam date. Well, I know how you think you can. And I'm really not that surprised. A little bit with you, less with your buddy. But the exam is the 15th, correct? And it's a Wednesday.
6 o'clock.
6 o'clock.
2:07.
Guys.
Okay, 2:07.
Yeah,
That's what I have.
Yeah, no, because
Really? What time?
it's going to have to be a bigger room. We've got a bunch of people.
6 p.m.
Okay, 6 p.m. the 15th, and likely it's going to be 2:04 or 2:06. We have another large group of people, so the reason it is a different night than the class, as a general matter, is so that it will not conflict with other exams that. In other classes that other people are taking. What is the 15th that's problematic for you and your twin sister? Not that it matters.
I had really good tickets for Alvin Ailey, and I can't go now.
I would have checked the exam schedule first, but you know.
Never up until now. Oh man, it's okay. 15. I got some A's.
So, all of you taking the exam, so I was going to say, you can get some cheap Alvin Alley tickets if you're interested.
We're cheap.
They're going to be cheap now for them. So if any of your family members are interested. Where is my rule book? Attachments and post-judgment remedies. And what I want you to start to think about, again, sort of transitioning from law student to lawyer, is oftentimes we tend to think, okay, we've won our trial, and now someone's just going to be writing out a check. And that is not the way it always works. You'd love them to be able to just the insurance company come in, here's your money, we'll take a release, we'll work out the terms of that release, which, by the way, obviously, we've never talked about that, but that becomes part of the process as well. If we're resolving a civil suit, and prior to a judgment, then most oftentimes the way that resolves is you and I come to an agreement as to what the settlement will be. And then with respect to the court, we file a dismissal under Rule 41 by way of a stipulation of dismissal with prejudice. And with prejudice means that the action cannot be brought again. So it's important, obviously, that stipulation under Rule 41 be with prejudice. You, as the attorney, are signing it because it is a court pleading. So the stipulation of dismissal with prejudice is filed in court. But obviously it's not going to be filed until you've worked out the terms of the settlement, and usually until you have the money in hand. Most settlements happen and the money's paid, and then we dismiss the court case, because you don't want to dismiss the court case and then not have them comply with the terms of the settlement. But the biggest thing that we work out then is a release. And the release can be as short as a page or two to as many as 10 to 20 pages, depending on the scope of the case and what the other side wants. And we've talked a little bit about that when we looked at Kaplan versus Feldheim. What provisions can go in there? How do you respond professionally to some of the requests about return of documentation, not to disclose information unless compelled by subpoena? And you got to think about that, by the way, because sometimes, obviously, if someone subpoenas information, you have an obligation to comply or then oppose it in court, and that could be an additional expense that you would have to bear yourself. And so normally the language I use on that is that simply that if subpoenaed, we will provide you notice that we've been subpoenaed, and it's your obligation then to oppose it. Otherwise, we're going to produce it within X number of days, the information that we have. And then the other part of that sometimes is the provision that they want you to destroy whatever information you have, whatever documentation you obtained in discovery. And I don't favor that myself, simply because I don't like the notion of destroying what might be evidence in a different case. So I may be willing to return you the information we've got, and whatever you do with it is up to you. But I will not, as a general matter, destroy what I have. I'll return it to you, because I think I have concerns in that regard as to what is intended to, obviously the intent is to make sure that that information isn't available to other litigants. And I do worry that that has problems from the standpoint of various statutes that do not allow you to destroy evidence. And certainly there's a protection within both the rules and the rules of professional responsibility that you have an obligation to preserve evidence once you know that either litigation has begun or it is likely to occur. There's an obligation to preserve the information for use during the course of that litigation. And then the last part of that is that there is a modern trend with respect to spoliation of evidence, meaning the destruction of evidence can bring or potential evidence can bring it gives rise to a civil suit simply for destroying what might have been essential proof that a party needs. So you don't want to expose yourself either. But the releases become part of the settlement if the case hasn't been tried. But sometimes cases have to be tried, and then even if they've been tried, we could still resolve it along the lines as long as the judgment hasn't entered under Rule 41 with a release and everything else. But there are other cases that are tried and go to judgment, and then the question is, well, what happens at that point? There's a couple rules to think about as we start to think about what we're going to do now that we've got this $2 million judgment. And we certainly would like to collect on that. The first thing to think about is Rule 62, and I don't think we've looked at it before, but here. But Rule 62 talks about whether that judgment will be stayed pending appeal. Just because you're appealing it doesn't mean that I can't start to enforce the collection or the order that was contemplated as part of the judgment. So Rule 62 talks about whether there should be a stay of proceedings, and as you look at Rule 62, there's an automatic stay under certain circumstances, unless there's been an attempt to try and enforce it. You can't enforce it until 14 days after its entry. Unless the court chooses to issue what's called a stay of that judgment. And if you look at the rules talk about under what circumstances a stay can be issued. And a lot of time what we're doing is we're trying to file motions to new trial or to vacate judgment and all the rest of it. But at the end of the day, most judgments that the jury has returned, in all likelihood, it's fair to say that most judgments are likely going to be entered, and then at that point the question is how are you going to enforce the judgment, how are you going to enforce the orders of the court. And the biggest thing to look at under Rule 62 is certainly for monetary judgments is that if there's going to be a stay, then you have the right to seek a bond for the purposes of that appeal. What the bond does is require the defendant then to post sureties for satisfaction of that judgment. And this becomes really important in a money judgment case, obviously, because it might take 2 years for the case to wind its way through the appeal process. There'll be other creditors, other events can happen, and so I don't care how long it may take if in fact I've got a bond for payment of the judgment plus the interest that will accrue during the period and any other costs that attach to it. So if the bond is sitting there that's going to protect you and make your job easier at the end of that process, that's one thing. But frankly, staying the judgment without the bond puts you at risk that other creditors are going to come in, or the business could go insolvent, and you've spent not just the time in the trial court, but now on appeal as well, and end up empty. So you want to look at trying to obtain a bond, and then the question is, well, what sureties would be sufficient under Rule 62 in order for you to feel comfortable that the case, at the end of the day, you're going to get satisfaction for payment of that judgment. If there's no stay under Rule 62, and maybe there's not even an appeal, So now we're looking at, well, what do we do? What can we do to try and look at satisfying that judgment? One thing you should have thought about, we looked at this early on, is, well, is there an attachment over any of the real property that the defendant might own? Did you seek an attachment at the outset of the case under Rule 4? And if you did, and the judgment is now issued, then one of the immediate things you have to do is take that execution from the sheriff's office and levy it against the real estate, to actually have the sheriff file it as an additional lien against the real estate. And the advantage to that is that your attachment and judgment are now secured as a lien against the property, and it goes back to the initial date of attachment as a matter of priority. And so that might give you a couple years worth of intervening liens and the rest. So you've got to take that judgment and levy it against the property. One thing you can do in thinking about a post-judgment remedy, if they own real estate and there is equity there, is to actually sell the real estate under the power of sale contained in the execution. And sometimes you see that in the back of the newspapers and the like, where they are selling whatever right, title, and interest they have by way of the attachment and the execution to whoever might be interested in purchasing it. Now, there are problems attendant with that as well. First of all, it's first in time, first in right. So whoever takes prior to the attachment or prior to the execution, those liens have priority. So if there's a first mortgage, whatever you're buying is subject to that. In certain states, in most states, they have protection for tenants by the entirety. You probably studied that a little bit in property. So if the property is held tenants by the entirety, you're obviously buying less than the whole of the property because there are survivorship rights. There's also exemptions from sale depending on whether there's homestead declarations and the like. All of these are potential impediments and that you have to think about with respect to satisfying that judgment. But then there's a couple of other things to start to think about. Well, what should I be looking at doing? Rule 66 talks about receivers. We looked at this before with respect to the Republic of the Philippines case. Receivers are normally appointed to satisfy the orders of the court where the parties are unwilling to, and especially in a post-judgment situation, the receiver has the power to take control over the entire corporation or the entity to carry out the court's orders. So a receiver under Rule 66 is a very powerful, significant remedy, and in order to enforce Rule 66, you would bring a separate suit on a judgment showing that the judgment's been unpaid and asking the court to appoint a receiver over that property. Rule 69 is with respect to the execution, and it talks about that you have the right under Rule 69 to bring what's known as discovery in aid of judgment. Prior to your having a judgment, what assets the defendant has, what wherewithal they have to pay the judgment isn't relevant or will lead to relevant evidence during the case prior to judgment. Once you have a judgment, now you can either do a deposition or interrogatories, any form of discovery to try and gather information as to what assets are available that the defendant has potentially to satisfy a judgment. Rule 69 is rarely used. It should be used more often when you've got an unsatisfied judgment, and to try and force that information to come forward, because sometimes it's much harder to get that otherwise. And so Rule 69 allows you to do discovery in aid of judgment, because other than whether there is insurance available, you can't, and what insurance it might be, during the initial part of the civil case, that information isn't relevant or discoverable. You can't ask about insurance and you can't ask what policies are available, but you cannot ask as a general matter about the assets of the defendant because it doesn't fall within the scope of discovery. I think the only time you could make a decent argument that it would is in the situation of punitive damages, where under those circumstances what assets the defendant has become important. Lastly, in this sequence, and it really isn't isn't related to post-judgment remedies, but it's a rule that you should be aware of and start to think about. It's Rule 68, and it's an offer of judgment. And I don't know why more defendants don't use it. But what Rule 68 does is it allows a defendant to make what's called an offer of judgment during the pendency of the case. And in essence, what they're gambling, arguing, trying to establish as a position is, I will offer you $10,000 for your claim, $20,000, pick a number, it doesn't matter, to resolve this suit. And it's a formal offer of judgment made to the defendant. If the defendant doesn't accept the offer of judgment, and if there's no response within 10 days, it's deemed denied, not accepted. And the judgment comes in for less than the offer of judgment amount, then the defendant at that point is responsible for all costs incurred after the offer of judgment, and one could argue that should include attorney's fees as well, which really is a game shifter. It's not always going to include attorney's fees. Oftentimes it doesn't, but even the costs could be significant for depositions and the like after the offer of judgment is made. What it forces the plaintiff to do is have a heart-to-heart talk with their client and let them know that, well, there is an offer on the table, it is serious, or at least they allege it is, and you can reject it, and perhaps with my counsel you will reject it, but understand what the ramifications are. And it's really this cost-shifting notion, which does mean that you can't just as easily think that the offer is frivolous or the case is substantially more. Because, as you know, we've talked about this, anytime you try a civil case, two main components you've got to establish: liability and damages. Oftentimes, if you're trying the case, if you truly have responsible attorneys on both sides of the case who've made reasonable assessments and risks assessments and the like, the reason you're trying it is because there may be problems with establishing liability, or there may be problems with establishing the level of damages, and that we just really have a disagreement on both. Well, the fact is, if you try cases and you try the right cases, you're going to win some, you're going to lose some. And so when your client says, well, okay, they're offering me $25,000 and it's by way of an offer of judgment, it's not just it's a reasonable offer. What they're trying to do is shift this whole cost notion. You have to understand that then if you get less than 25, losing here will mean that you owe them their costs, which some will argue that might include attorney's fees. And by the way, the other part of this, and we saw this in Methuen, and this is important to understand as well. Suppose I offer you the $25,000 and you take it. You have now are a successful litigant. You have won a judgment of $25,000. If it's one of these statutes, like a 1983 or an antitrust action or a 93A action, then the argument is, as the successful litigant, I'm now entitled to an award of my attorney's fees as well. And so be careful what you do as the plaintiff, the defendant as well, in making an offer of judgment, because what happened in Methuen is, I think they made an offer of judgment of $50,000 or $100,000 for the police chief's claim. The plaintiff was smart enough to recognize that that was a reasonable offer, especially coupled with then potentially hundreds of thousands of dollars that would due in attorney's fees under the 1983 action, again as the successful litigant. So if you recover a judgment and there's attorney's fees provisions in the statutes, and there are in many, then at that point now that also comes into play with respect to being the successful litigant. So Rule 68 has to be used judiciously, but it has significant ramifications on both sides. And I don't, for the life of me, understand why defendants don't use it a little more often, simply because it means my client and I have to have a more serious talk about the risks of going to trial, and anything that might scare a litigant into walking away sooner rather than later is a very valuable tool for a defendant. Gary, you had a question?
Yeah, so typical scenario might be a verbal, unofficial offer first, and then if you think, is that typically the case? And then if you really want to put the other party on some kind of, fee possibility, then you'd make it official if they didn't take it verbally.
Well, if you said, yeah, usually we'll talk. What are we looking at? We'll try and negotiate. Maybe we can get close, or maybe in a lot of cases we just can't get close. And I've said this, I think I told you this before. I was being sued down in Rhode Island for a claim for one of my sons driving down there. And I said to the lawyer, I said, I don't understand why you're not making an offer of judgment. I mean, the likelihood of a zero verdict was ridiculously high in my opinion. Make an offer of judgment of $1, something, so that the costs will shift. And the fact is they didn't want to do it simply because they also expected a zero verdict. But to me, there's nothing to lose by way of this shifting from a defendant standpoint. And so I think it's, yes, we could do it. We're at an impasse. I'm going to make your analysis a little hotter. Okay, I intend to make a formal offer of judgment of $25,000 because I don't think you can get more than $25,000. And that's the it's more tactical than when we try to negotiate. I had it used against me one time. I had the plaintiff. We had two defendants. This bizarre auto accident that was set in motion, say 100 yards ahead of us. There was a collision. They sent cars spinning, and then 100 yards back, my person's sitting there having nothing to do with the first one, and gets hit with the cars as they, spun out of control. And as it turns out, the one that didn't cause the first accident made an offer of judgment to us saying, and the person had substantial injuries. I mean, substantial. And their offer of judgment, and I think it was about $50,000 at the time. They're saying, listen, this is what we've got. I think there's as good a chance, and frankly there was as good a chance in that case, that the jury could come back. Ash is responsible, or Ash isn't, Pat is, or Ash and Pat are. That easily, depending on the jury. Someone owed me, okay? Someone owed, because we did nothing. We're on the right side of the road, perfectly sober. We did nothing. But I could see trying this case where the jury could say, it wasn't Pat, it was Ash. No, it was Ash, not Pat, or it was a combination of the two. And the person who thought they were the less culpable of the two, at least initially, said, I'm getting out of this, because it potentially was certainly high six, maybe a seven-figure verdict, and they wanted to try and get out. So what they did is they made an offer of judgment, and $50,000's not nothing, obviously. And now we've got to have a serious conversation of, the way this could fall is I could see this person didn't trigger the first event whatsoever. That a jury could find that they're not responsible at all. It's all falls on Ash. And so I thought it was a very smart move. And it wasn't, you offer me $2,000, $3,000, that's easy. You put enough money up that maybe we can negotiate a little bit with the medical providers and the like, and you get some money to fund the rest of the case. There's some value to it. And that's where I think you see it a little more, because it's a tactical move designed to try and shift your thinking and your client's analysis a little bit. And under those circumstances, very, very smart move.
So then you accept that offer, let's say.
They're out.
Now they're out, and it's all, the onus is on Ash.
Yep.
So the jury just has one culpability to determine.
And Ash is going to be pointing his finger at you whether you're in the courtroom or not.
Right.
But that's the way it works.
But you're out.
But there's advantages to that as well, because I'm not confused about who I think is at fault. It's Ash. And now I direct my guns at Ash. And again, that all becomes part of your analysis as to who you want to be left with against the case. The fact is that at that point, your client has something, You pay for some of the expenses as well, because you needed accident reconstruction experts and the like. So some of that becomes important to your analysis as well. But Rule 68 is a terrific vehicle for defendants to use as a means of forcing plaintiffs to take a harder look at that case and maybe to have a serious conversation with their client so that they understand what the risks are. There are other methods post-judgment of trying to enforce that judgment. There's what's called supplementary proceedings. It's a district court action where someone comes in and you ask them what their assets are and the court makes an order. It's really the order of payment on a monthly or weekly basis. Very ineffective. I can attach your wages. I can seize your motor vehicles. I can seize any assets you have, either by way of the execution or attachment. And at the end of the day, that's what we have to think about, because you might well have a substantial judgment, but if you don't have any money, the paper isn't worth anything, so you've got to try and figure out then how to satisfy it. There's MCLE books downstairs that you can look even harder at that if you want to try and think about what post-judgment remedies are. But as you can see here, when we talk about post-judgment remedies, we're going to look at these cases. We're talking about receivers, we're talking about discovery under Rule 69. What we're looking at is the attachment, and then the levy under the execution, and the potential seizure of assets under that execution, like wages and real estate and motor vehicles and just about any other thing that you might possess within reason can be seized or attached. Your wages, there's an exemption amount, but it's very small. Your real estate, if it's held by T/E, there's an exemption amount. And I think you get your motor vehicle, I forget what the number is, but again, it's relatively low. But obviously, to the extent you have a car loan, that has priority over anything else on that vehicle. To the extent you have a first mortgage, whoever comes after takes subject to those as well. Questions on these rules? Or go ahead.
When we're talking about Rule 66,
Yep.
Receivers, they can operate a corporation to the point where they can liquidate the corporation to satisfy a potential judgment.
Correct. And that's for corporations, that's, unless they own real estate, that is the most effective means we can take. The court, the Superior Court, or the federal court can appoint a receiver over the corporation. The receiver then comes in, is the chief executive officer, is the board of directors, is the president of the corporation, takes control over the management of that corporation, changes the locks, does whatever it takes to control it, and in fact, to the extent there are assets available, will satisfy the judgment. To the extent there are not, they can liquidate the assets of the corporation and shut the corporation down in order to satisfy the outstanding judgment.
But it's an extraordinary remedy.
It is an extraordinary remedy, but we also have a judgment that says, and by the way, in that case, it is an extraordinary remedy, but that was a prejudgment. Okay, so they were saying this bad things could happen. Well, now bad things have happened. You've got a judgment outstanding against the corporation, and a lot of times it's in order to perform certain things, to clean up Boston Harbor, to desegregate the Boston housing, whatever it is, and if the management won't do it, then the receiver can. But in money judgment cases, you have a judgment from the court that says pay X number of dollars to the plaintiff. You're refusing to do it. It is still an order of the court. And while it's an extraordinary remedy, tell us what the alternatives you have to satisfy this judgment. Because the fact is you can't allow it to go unaddressed. And you want to go bankrupt, you can do that. That's one of your options. You want to sell some assets, that's one of your options. If you can present to the court some reasonable effort to try and satisfy it, they probably won't do the extraordinary remedy. But in the event that you're unwilling or unable to offer a concrete plan, the likelihood is that receiver will be appointed and that corporation may well have to be liquidated in order to satisfy it. I mean, you just can't ignore the judgment of the court even for money. Especially, those are all the auctions and the different things you see in the newspaper from time to time. Questions on that?
Those judgments are good for what, 20 years?
20 years, and they can be renewed. So
And they're accruing interest the whole time?
they accrue interest at the whole time, and the interest is actually a pretty good rate. I think it's generally, at least it had been. I don't have any outstanding now, but they've been, usually it's about 12%. I think federal system, it's a couple points over T-bill rate. So it's still better than what people are going to do. But what you're worried about is that you have to have assets. At the end of the day, if there's no assets, I've got a piece of paper worth a lot of money. Well, I've got a piece of paper that says it should be worth money, but it's not. And I've told you, I've had situations like that where after the fact, when we were in Boston, someone came in with a judgment against a ladder company for like $750,000. Company was long gone. Guy was crippled. But that's why at the front end of this, you got to look and think about it. I think I'm sure I've told you this. My uncle was killed in a car accident in South Carolina on the way back from Florida by a 17-year-old with a 3-year-old in the back seat on a slick, rainy highway, slammed from behind. No, I mean, clear liability, wasn't a problem. The fact is, she had nothing. The prospects of anything were dim. The policy was 25 or 50 grand. They were willing to pay it. That's what the case was worth, because you could chase it, you get $1 million judgment, but there's never going to be any money likely coming out of this or the family to satisfy that potential judgment. And that's why the part of the process that I'm trying to stress to you is that's at the outset what you should be doing. You need to be looking at that at the outset. What will my avenues be? You know, I've really started to think, and I haven't started, I just sort of in my own mind. I would never, if I represented that Phantom Fireworks up in Seabrook, I don't think I ever would have disclosed, unless forced to, that was my gunpowder in those bombs. Because I don't think it's going to be too long before someone's going to put pieces together and say, is there any way we could establish a claim? You know, when I first heard that the fire down in Rhode Island there at the club with the, was it White Snake Station? And they said, oh, they're suing Budweiser and they're suing the radio station. This was a police, Rule 11. And my understanding is they all ponied up before that case was over. So I wonder whether, and I don't know, I haven't done any research obviously on it at all, but is it that big a stretch to say you sell fireworks knowing that it's illegal to use them in Massachusetts and the person's from Mass? I mean, now no one could expect them to be used here, but and what do you think? Would you, as civil lawyers, bring that suit? They must have a huge insurance policy, right? You run a fireworks place.
Was it sold as gunpowder, or was it sold as...
No, sold as fireworks, but then they deconstructed it and took the powder out of it to make it.
But do they ID?
Yeah, they knew him. That's how they found him. They said, oh, we found him, and now my understanding is they're saying the explosive ordnance that was used was likely firework.
Did it matter that they deconstructed? I mean, the fact that they just used them to hold them up, I mean...
I don't know. I've got a bunch of people that have lost their limbs, and I'm trying to figure out who's going to pay for this. And
I think you can make a case against them anyway.
Yeah, but I know. But do you think it's... I don't know whether... I don't know. I haven't done any research. I'm just thinking that my guess is someone, as you start to look at it, I mean, these two kids don't appear to have a dime, so suing them is useless. So, does John Hancock still support the marathon? Do you know? It used to. Well, does it say? It used to say it, right?
Yeah.
I mean, John Hancock, post security. But at the end of the day, we know there'll be suits, and the point is, you need to do that investigation at the outset. Who main parties, and who can be holding the bag here at the end of this that can pay? Because if I just pick, look, if you sue either of these brothers, okay, you should, you know. You don't need to go to law school to be able to get a judgment against those two based on the evidence that was seen, right? But you're never going to see a dime of it. So someone's got to start to think, okay, so who else within this circle potentially might have assets, and how do I know that if I get to the end of the line, the finish I want, that I'm going to be able to get compensation? And that's what you have to think about, and you need to think about it at the outset. That's why we look at attachments at the outset, or we look at, listen, it's not worth the 2,000 or 3,000 hours. At the end of the day, like my uncle's case, there was not going to be anything. And you got to be realistic about investing resources in a case where there won't be money. Go ahead, Gary.
So you mentioned they sued Budweiser. So what are you saying they shouldn't have? Because I did that case for motions, and Professor Sharaf was saying the insulation company got sued, and that was right to sue everyone. And so what was wrong if there was a reason to sue Budweiser?
Well, okay. At least when I first, so they sold Bud in the club. That means Bud somehow is responsible for
Maybe not
someone setting off fireworks inside a small, crowded club. I mean, at the core of it sounds like a really stupid idea, doesn't it? So how does Bud become responsible for that?
Or probably a sponsor of the band.
I think they were sponsor of whatever the night was, and that's my understanding of the road it started. So I mean, how many clubs have Bud nights or PBR night? Or call it whatever you want, but that means they're responsible for whatever else takes place that night. So and that's the thing. I understand what you're saying, and listen, as it turns out, it was not a silly move because parties paid. But I guess I'd need to know more facts, and I need to know more about this other situation before. As a general matter, the idea is to sue everyone. Well, that's fine, except if you're Ash, all of a sudden I'm swept. My name here is in this bombing thing because what's the kitchen? I worked at kitchen, etc. And the kid came in, and I gave him the same one I would have given anyone else, the pressure cooker. Me, I'm in this. Yeah, and that's. I asked this before, and you might. In Sid Pro. It is easy for you guys as lawyers to just put someone else's name as a defendant, right? Because like you said, sue them all. Sue them all. So just stick their names in as defendants. But there's some heavy baggage coming for the defendant at that point. What the hell is this?
But within rule of law, Rule 11.
Agreed. And that's what I mean, is that it's easy to think, TD says, sue everybody. And as a general matter, that's correct. But where's the liability and where are the facts that support it? Because that's what Rule 11 is designed to do. And frankly, if I'm on the receiving end of that, and I'm representing Ash, and he was simply the store clerk who you gave, I'm getting $8 an hour, and you gave me whatever the money was for the thing, and I gave you that, and now you say, now I'm responsible, I'm supposed to know you're going to go do something like this with a pressure cooker. No, we're coming at you with Rule 11, and we're coming at you with the counterclaim, because that doesn't seem based in fact. But with that said,
I guess Budweiser's a bit like for instance, the insulation company, they could argue that it wasn't well insulated and the fire could have, I don't know.
It wasn't fireproof.
It wasn't fireproof. But again, even that, and I don't know enough of the facts, but I can sell you insulation, but I'm not sure it's appropriate for your purposes. If you choose to use it, I mean, if we set off fireworks in this room and the ceiling looks about the same height, my guess is someone's going to get hurt, right? And it doesn't matter how well this room. No. You ever touch the end of that sparkler?
They were illegal in Georgia too.
So, okay, listen, we're getting a little off point. The point I'm trying to convey to you is the starting point for this type of analysis is at the outset, not 2.5 years later when now you've spent your sweat and lots of money and effort into this, and you don't know whether you're going to be able to get paid. You need to know at the outset, if I put my time and investment in here, that there's money. And you then need to take the step back and say, and how do I protect and ensure that that's going to happen? Because things change dramatically in 2 years. Things change dramatically in 6 months. We rented the 3rd floor out to Enron. Oh, they're going to build it out. It's going to be all fancy. One of the largest companies in the world. They got billions. Before they ever started work, unfortunately. I wish they had finished the work. Before they started work, the whole scheme was uncovered, and they went belly up. and as it turns out, they'd never had a dime. But at one point, the company was worth billions. Things change quickly sometimes, and what you need to know is there a way to protect against that during the course of the litigation? That's what you decide to do. Let's take a look at this digital equipment, thinking about things change. I don't think DEC is even in business anymore, is it? At one point, it was the largest computer corporation, one of the largest, certainly. Was it? Second largest? Yeah, right, that's right. And now it no longer exists. The law firm I was with I guess I got there in '73. I was still in high school, so just to be clear. I was a junior in high school. They bought a DEC computer, one of the first ones, and it was blue like this room, and it just about filled this room. What my guess is, not even this, my phone can do these days. They housed in a room this big, and it was one of the DEC computers. So digital equipment sues from around here. And digital sues Curry Enterprises. And, we haven't looked at a lot of civil federal statutes that are used frequently in litigation. We looked at Mass 93A, but RICO has a lot broader application than you'd think. It was originally, if you look at the name, it's Racketeer Influenced and Corrupt Organizations Act. But it has significantly broader implications than, just sort of mob businesses. Because in order to establish a RICO claim, it only takes 2 or more predicate criminal acts, violations of federal law. And frankly, if you think about all the electronic transfers and things done interstate and the like now, RICO is another one of those counts that oftentimes we look to plead because it has this horrible connotation to accusing someone of a RICO action, but it also has some pretty powerful remedies that are contained within it as well. This is a civil suit. They're looking for an attachment. The district court magistrate Judge Bowler, you know what interesting fun fact about Judge Bowler is?
What's that?
No?
What's that?
She's got the bomber case right now. She's the one that did the arraignment on the marathon bomber. And they brought an attachment against the defendant, and in order to obtain an attachment, they only had to show that they have a reasonable likelihood of success, and that the defendant doesn't have any insurance available to satisfy the claim, or that to the extent they have insurance available, it is insufficient to satisfy the claim. So in order to get an attachment, pre-judgment, the standard is relatively low. And it says, as you see here, it looks at Mass Rule 4.1, even in federal court, because that's the rule on attachment. They borrow the Mass Rule in order to look at attachment. So, I mean, you read the case. They're looking for, this court approved 4 writs of attachment, including an attachment in the amount of $3 million against property owned by defendants Raymond Curry and Mary Curry, and they're owned in Clinton. And what happens then, if they're allowed, is the sheriff takes that writ of attachment that you have provided to the court and they sign off on, that's filed at the Registry of Deeds, so it operates as a lien against the property, and everyone who might have an interest in the property or be interested in the property can see it and go from there. What the defendants then, they sought a further review of this, and then it says, the plaintiff and the Curry defendants filed a stipulation. The Curry defendants sold the property, Green Street property, to Weetabix, and place 2 checks in the amount of $1,200 and $23,000 in escrow as security for the plaintiffs. So I guess I'm wondering a little bit about a couple things. And this makes reference to Federal Rules of Civil Procedure 64, which we didn't talk about. We should have when we looked at the attachments. What do I need to show? What do you need to show in order to obtain the court approval of an attachment over the defendant's property? The existence of a reasonable likelihood that the plaintiff will recover judgment in an amount equal to or greater than the amount of the attachment over and above any liability insurance known or reasonably known to be available to the defendants. And this quotes my book. It's page 20, and it's looking at Rule 64 and Mass Rules Civil Procedure 4.1. Are they likely to prevail on the merits? I mean, this is a relatively low threshold in order to get the attachment. And the attachment becomes very important because it's going to secure their place in line. In a case like this, it might take 3 years for it to wind its way through the process. There's a couple notes here that I've got questions about. It says, if you look at note 2 on page 20, same page we're already on, now again, you saw they brought a motion to modify the attachment. And it says, without elaboration, without providing the court with a memo in support as required by LR 7.1A1. However, the Curry defendants state that they have a good defense of this action. What does that reference mean? LR 7.1A1. Anyone know? Providing the court with a memorandum in support as required under LR 71A1. LR are the local rules. When we look at, I've got my little Federal Rules of Civil Procedure booklet here. So this is the motion for summary judgment under Rule 56 or 66 or 69 like we talked about earlier tonight. In addition to these rules, which you have studied before when we did Civ Pro, within every federal court there are also local rules that you have to comply with. To the extent you do not comply with the local rules, and these are usually sort of housekeeping matters and the like, but to the extent you do not comply with the local rules, they're going to deny you motions. It might be on the font size, it might be on the length of briefs, it might be on the requirement to confer prior to filing any motion in the court. What I want to make sure you understand, and we saw this before, but I want to make sure I reinforce it, that if you're going to practice in federal court, there are local rules that have to be complied with, and not the least of which these days in this circuit is that you have to file everything electronically. Which isn't a bad thing, but and it's not that complicated, but you need to know how to do it. You know, there's a little tutorial right online if you wanted to go to the Massachusetts Federal Court and see it. It's not complicated, but you need to have some basic computer skills to be able to do it, or know someone who does and is prepared to help you. But the local rules have to be consulted before you do virtually anything in federal court. There are also rules in the Superior Court, and rules in the District Court, and rules in the Probate and Family Court in Mass as well, in addition to the rules of procedure that are at work here. So that's the local rule, and they didn't file the memo that's supposed to be with it, and so therefore they're going to lose because of the failure to comply with the local rule. Footnote 7 on page 21 says the plaintiff's complaint is unverified and therefore fails to provide an adequate basis to support an attachment. What is an unverified complaint?
Is it an unsigned complaint?
Well, unsigned would be, who signs the complaint? Plaintiff's attorney. So, and the plaintiff?
All the parties signed a verified complaint.
Say what?
I thought a verified complaint was a complaint that all the parties signed.
All the parties? How do I get the defendant to sign?
Well, not all the parties.
So what party? I'm just using your words. So what party?
can't make the defendant sign it, but I guess.
No, so that wouldn't be all the parties. So you tell me what you meant.
The parties that would sign it, I guess.
Who's that?
Nice try.
By the plaintiff.
Probably the plaintiff. So that's all. That's all a verified complaint is, that the plaintiff signs it. I'm looking at Rule 65, which my recollection is we talked about before. It says Rule 65 and then A. Specific facts in an affidavit or a verified complaint clearly show the immediate and irreparable injury or loss or damage. So what's that mean?
Under the penalty of perjury.
Yes, Ash. Okay, listen, we've talked about this, and seriously, this is important to Rule 65, especially if you're seeking injunctive relief. A complaint is nothing more than the plaintiff's allegations. Okay, the attorney signs it, and the attorney knows it, and by signing it, the attorney saying it complies with Rule 11. But that's not enough to ask the court to issue an order to bind someone to do certain things. And so what Rule 65 talks about is if you're going to move for injunctive relief, it has to be by way of affidavits or verified complaint, both of which get us to the same point. An affidavit, what makes something an affidavit is that the person has signed it based on their own personal knowledge and then under the pains and penalties of perjury. It's a sworn statement as to the truth, and it has ramifications to it, obviously, if it's false, because one thing would be perjury. A verified complaint is a complaint that's still written by the attorney, but then it has what we call a jurat on it, where the plaintiff has read it, the complaint, and it states, I, Michael Coyne, the plaintiff in the above entitled action, having read the complaint, state that the information contained herein is true, based on my own personal knowledge, signed under the pains and penalties of perjury. Michael L. Coyne had stated. That's what makes it verified. I have sworn to it. Now, there'll be some times where I can't swear to it all. And some of the allegations then in the complaint have to be said upon information and belief. Sometimes you see that. Upon information and belief, the plaintiff, Michael Coyne, states that Cindy has been selling drugs out of her home. So I'm not saying I know it's true. I'm saying I've heard this. And so then if the complaint has allegations along those lines, then the jurat has to say, I, Michael Coyne, being duly sworn, deposed and stated my own personal knowledge that the facts stated above are true, except such those that are, and this is all way too legalese, obviously, but this is the way I would write it unless I'd look at it, except such as those that are listed upon information and belief, and those of which I believe them to be true. Signed it, Michael L. Coyne, with the date. The verified complaint then is a sworn statement. And what it allows the court to do is these aren't allegations anymore. These are someone's sworn position. And it gives them the ability under Rule 65 to move forward with the TRO. And that's what the court is saying in this footnote 7 is absent an affidavit or a verified complaint, the plaintiff shouldn't even be getting any form of relief by way of injunction. They don't need it for attachment, but oftentimes an attachment, as it said earlier, is supported by both a memo and an affidavit that states what the facts are that would show the reason for why the 5-part test is satisfied. If in fact it's injunctive relief, if it's an attachment, only that reasonable likelihood of success and no no insurance available to satisfy the entirety of the judgment. It says to you on page 22, if what a RICO action is, it's a person who's engaged in a pattern of racketeering activity, who derives income from it, and then to some extent is involved in interstate commerce. That doesn't take a lot to do that, and if you look at 23, the pattern is further defined as the plaintiff has to show 2 or more predicate acts of racketeering activity that follow within a specified time period. The fact is that that's a pretty low threshold in a lot of situations to be able to show it. This case is not going to be very difficult to be able to establish that. And at the end of the day, you do have the ability to bond over the attachment, and that's what they did here. The last case we've got in this sequence is the receiver case, and that's the aviation supply case. Here what we've got is sort of a straight judgment creditor, hasn't been paid, wants their money, and there's no good basis for why the defendant hasn't done more or done something. And, as Ash said, while it's an extraordinary remedy, and it says that under Roman numeral 2 here, a receiver is an extraordinary equitable remedy that is only justified in extreme situations. But, there's some fraud potentially going on here that the court is concerned about. And we've got, and I think this case actually lays out a nice little example about discovery and how you would use the process to try and obtain this information. Here the receiver wants to get some information. At the end of the day, you've got to be familiar with these types of remedies, because not every case comes with it. A check at the end of it just voluntarily given. And here what they're looking for is the receiver, because there's been really a history of non-disclosure and avoidance. And while it's a drastic remedy, what are the alternatives when you look at this case? And I mean, I've seen it tons of times, despite the fact that it is, in the case makes reference to it, an extraordinary remedy. But I think under these circumstances, there's really no other likelihood that they're going to receive any money. This case makes one other reference that I want to just touch on before I let you go. I'm not going to let you go. I actually need you to get the evaluation forms, then you can go. The notion of the fraudulent concealment and the fraudulent transfer of assets. There is a separate suit post-judgment that you have the ability to try and set aside what you think potentially are fraudulent transfers done in order to avoid the payment of creditors or to render you insolvent. And it happens, and so you have the ability, as we saw really when we looked at some of those constructive and resulting trusts. The court has various equitable powers, in some cases statutory powers, to set aside, you need another one? To set aside transfers if they think those transfers were done in fraud of creditors. And what we're talking about isn't good planning issues, so to speak. The fact that a doctor comes in or a lawyer comes in and says, I want to form a PC before I begin practice. Nothing wrong with that. But the fact is, if it's going to, at the end of the day, if you're transferring assets to a spouse or to anyone that either renders you insolvent or is done with the design to avoid the payment of creditors, then at that point the court has the power to come in and set aside those transfers, put the property back where it was, and allow the creditors to get access to it. So sometimes you will come in and you'll trace an asset and say, whoa, just like we saw in the Pier 4 case, where just immediately before suit was filed, they transferred assets to a separate trust in order to try and preserve the asset, even if they did lose the litigation. The court has the power to set aside what they see as fraudulent transfers, and that's another potential remedy you'd be looking at, assuming you saw transfers that took place with either the rendering of the defendant insolvent then, or designed to avoid the payment of those creditors. Either way, the court then potentially has the ability to set aside those transfers, put them back where they were, and then you can try and seize them as an effort to try and satisfy that judgment. Questions on that? We've got class on Thursday. It's our last class. Let's talk about the exam, what questions you have. I think these last few cases are important to start to think about putting it all back together. A lot of these things that are mentioned here we've touched on from time to time, and I think the big thing about the exam is now pulling it all together, both the substance and procedure, and being able to walk through the process and to be able to explain your thinking clearly. I heard a student who was successful on the bar exam who had taken this class before giving sage advice earlier today. Look at the old exams, write the old exams, think about them, and be prepared to spend 2.5, 3 hours impressing me with the depth of your knowledge about both the procedure and substance of remedies. And obviously, it worked for her, and she passed the bar in the first time, so that's what I want for you. So please try and follow that wise advice. Questions? Who's going to collect these from me and bring them to the registrar? Okay, Kelly will. Just will pass them back. You got a question?
Yeah,
go ahead.
Side question about RICO. Real back.
Yep.
So the RICO violations can be civil as well as criminal?
Yes. Yes, and you know, it's one of these like 93A that it's. I stretch. If 93A, if I have a credible argument under Rule 11, I'll stretch to add it in because it adds in the attorney's fees and the doubling and trebling provision. And the same thing with RICO. RICO covers a lot of broad situations, and I see it a fair amount in civil actions, contract actions. I've got one now. I think it's likely to stay in state court and we'll add 93A, breach of contract, unjust enrichment, a couple others. But if there had been some federal implication to what they would have done, RICO would have been one of the counts that would have added in as well. It's got a pretty broad application, but yeah, it definitely is civil, and you see it a fair amount. Okay, we'll talk on Thursday. So whatever other questions, think about it. You know, I always tell students one important thing I think to be thinking about is, okay, what are really the 30 concepts you should know extraordinarily well for this class that you might not have known or not known as well as when you started the class? Because I always see every class as sort of learning a foreign language. So what would they be here? And again, I think some of it is more familiar with you because I see remedies as an extension of Civ Pro. But certainly you must have a greater depth of knowledge and ability to use those concepts in a broader basis now from having taken remedies. So what would they be? And I think that's important to think about what you think those might be.